answer to that question is almost invariably yes. But obviously it can depend on a whole range of issues and circumstances of individual cases. In Queensland, the starting point though is that with a few important exceptions, there is a presumption in favour of bail. These days, the police don't have to arrest you to charge you with a criminal offence. They can simply give you what's called a notice to appear, which requires you to come before a court on a nominated date to face the charge. And then when you get to court, the magistrate will deal with bail and will normally give you bail going forward. But if you're arrested by the police themselves can in fact release you on bail. And if they don't, they have to bring you promptly before a court so that you can make an application to the magistrate for bail. In the vast majority of cases, bail will be granted either by the police or by the magistrate. In the case of some really serious offences, such as murder, a police officer or a magistrate can't give you bail, and in those circumstances you have to go to a Supreme Court judge to get an order for bail. But of course the question of whether you ultimately get bail, whether it be from the police or from the magistrate or from the Supreme Court, will always depend on a variety of factors, including how serious the charges are against you, what your personal circumstances are, or whether you've got any serious criminal history, whether you've ever breached bail before, and so forth. Taking all those things into account, it's usually only in respect of the most serious offences and in more extraordinary circumstances that bail is refused altogether. If both the police and the magistrate refuse you bail or aren't empowered to grant you bail, such as in murder cases, you can make an application to a Supreme Court judge. That involves a formal application and supporting affidavits and so forth, and it usually takes about a week or so, sometimes more, to bring that hearing before the court. But it not uncommonly happens, and it's not at all unusual for the Supreme Court to grant bail even after police and a magistrate have refused it. In some very serious and exceptional cases, you have to demonstrate to the court why your detention in custody is not justified, but for the most part, there is a presumption in favour of bail, and the majority of people charged with an offence in Queensland will be promptly released on bail pending the hearing of their case.